when the single witness to a crime is impeached about the nature and circumstances of the crime itself, does that justify dismissal of charges? To find out, you have to read People versus Howard, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Charles Howard. The citation for this case is 2025 New York Slip Opinion 00804, published by the New York Court of Appeals on February 13th of 2024. The issue in this case is whether impeachment of a sole witness to a crime creates a situation where the charges should be dismissed as hopelessly unclear as to whether a crime has been committed or not. To understand and appreciate the context of this case, what you should know is that impeachment, first thing is that impeachment is testimony designed to undermine the credibility of a witness. That's what impeachment is. It's different than offering something for its truth. Offering evidence for its truth means that you're supporting that the thing that you're offering actually happened. Impeachment is to say you shouldn't believe somebody else because they have been impeached in this particular circumstance. The other thing you have to know is that there's a couple of cases, particularly People versus Ledwon, which is from 1897, and People versus Jackson. But Ledwon says that when there is insufficient evidence to warrant a conviction, when the evidence is not sufficient to justify a reasonable finder of fact in deducing or inferring that a crime has been committed beyond a reasonable doubt, the judge has the ability to not give it to the jury. It's the duty of the court to advise the jury to acquit, and the judge has the ability to actually remove the case from the jury if that's the case. In that particular case, motive was what was presented, and motive alone is insufficient to prove guilt. You can't say, well, he had a reason to kill the person, and therefore that's why we should convict him. That's not sufficient. Jackson came, almost 100 years after Ledwon, but Jackson says that when all the evidence of guilt comes from a single prosecution witness who gives irreconcilable testimony, pointing to both guilt and innocence, and the jury is left without any basis to conclude either one, then that should not be submitted to the jury. That's a Jackson dismissal. So if a person says that there was a murder and a suicide, those are irreconcilable, and it should not be presented to the jury as a murder case. Okay. So what are the facts in this case? The facts are that at the trial, this is a robbery case. At the trial, the victim testified and said, I was sleeping on the subway. I fell asleep on the subway, and I woke up to find, allegedly, the defendant standing over me who had been sawing at my pants with a box cutter, and he held the box cutter threateningly, and he demanded I give him all my stuff, and I gave him my wallet, and he ran away. Okay? Although at the same trial, a police officer testified that several hours after the crime, he interviewed the victim through an interpreter, and the victim at that time said that the defendant was standing over him when he woke up, and the defendant ran away, dropping the wallet or taking the wallet and running, something like that, inconsistent with the defendant standing there holding a box cutter, threatening him with violence. That was presented by the defense through the police officer as impeachment to try to undermine the credibility of the victim of this robbery on the subway. The victim said, when confronted about this, the victim said he didn't remember making that statement to the police officer. The defendant was convicted of robbery. He appealed, saying that this should have been dismissed under Jackson. The appellate division affirms the conviction, and he appeals to the Court of Appeals. And the question here is that statement that allegedly he made to the police officer hours after the incident, saying the defendant ran away without threatening him, inconsistent with, which is theoretically inconsistent with his statement the defendant threatened him with a box cutter? Does that mean that the Jackson dismissal should happen? That because he's the only witness to the crime and he is given information that's both consistent with guilt and inconsistent with guilt, does that mean it should be dismissed? And the holding from the Court of Appeals is no, it does not mean that. And they say, this is their quote. They say, when an alleged contradictory prior statement is admitted solely for the purpose of impeachment, which is what the case was here, the rule of People versus Ledwon and People versus Jackson is not implicated. So here, it's not that the victim said he threatened me and he did not threaten me. Those are both offered for their truth, and they both cannot be possible. That's not what happened here. The victim said he threatened me, and somebody else came and said, well, he said something inconsistent. which is impeachment. And that is not the same as a Jackson dismissal where there are two irreconcilable statements of fact. So the conviction is affirmed. There is a concurrence by Judge Garcia who says this is not even irreconcilable. This is not even impeachment. It's not even contradictory, because the victim didn't say. The victim said, "I don't remember saying that to the officer." But ultimately, the holding here is that when it's impeachment, it is not a Jackson dismissal, and that's the case of People versus Howard. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.